Hi, my name is Pouyan Darian. I'm the principal attorney here at Darian Immigration Law, and what we focus our practice primarily on is adjustment of status for family members, citizenship, visas, and other categories for green cards and work permits. Today, the topic I want to discuss with you is whether you really need an attorney if you're filing for adjustment of status, a green card for your spouse. So this situation specifically refers to a fact pattern where an immigrant entered the U.S. with inspection, a visa, or they were paroled in, or they entered with the visa waiver ESTA program, and they're married to a U.S. citizen and now they want to adjust their status. So people want to ask, do I really need a lawyer to do this? My cousin did this without a lawyer, my friends all did it without a lawyer, or they know a guy in the community who will do it for half price. The answer is kind of complicated. So just a little background. I'm a first-generation American, and when my mom came to the United States, she did the paperwork for our entire family. It was all successful. We're all citizens. But to be fair, back then, the forms were much shorter. And even just 2 years ago, the petition for an alien relative, the first form you need to file, the I-130, was just 2 pages long. Now, that same form has 2 different parts, which have a grand total of 18 pages. So the same form was 2 pages just 2 years ago. Now it's 18 pages. By comparison, the green card application was, I believe, just 4 or 5 pages a few years ago. Now it's 18 pages. They're looking for many more grounds of inadmissibility to deny you, especially with this current administration. So yes, you can do it yourself. It's possible. I have clients who do it themselves even today, but you need to dedicate a lot of time to reading all the instructions for every single form, and don't get caught in the trap of going on the online forums like visajourney.com and all that stuff, getting confused about the number of passport photos you need to submit and all that stuff. Those are all in the instructions. The problem is that many of the instructions on the USCIS website, where you can download all the forms for free, have somewhat contradictory instructions. So I want to discuss the pitfalls that people commonly incur when they do it by themselves, so that it can help you avoid those if you choose not to hire an attorney to help you with this process. One of those pitfalls is the legal fee. So people go online and they see, okay, I need to get form I-130, I-485, the green card, the work permit application form, advance parole, affidavit of support, and then all these G forms, G28 for an attorney, G1145, whatever. There's like 7 or 8 different forms depending on your situation. Each of these forms are free, and in the instructions, they have a fee. If you add all of them up, it adds up to a massive amount. But the total fee that you need to know for a one-step adjustment of status process is $1,760 for all of the forms. The work permit, advance parole, all those fees are included in that $1,760, and that $1,760 is really for just 2 forms, the I-130 and I-485, and if you pay those fees, everything else is free. Send it all in the same package. This is a mistake a lot of people make. And that ties into the second mistake people make, which is filing it in 2 different steps instead of all in one step. So the way some people do it when they don't speak with an attorney or have advice, or they use a non-attorney, is they file the family petition first, wait a year for that to get approved, and then they apply for adjustment of status. This will add at least a year to the process, and it will take at least a year longer before you receive employment authorization. So this is a huge problem that people are incurring. I mean, it's not going to have your case denied, but why wait an extra year for employment authorization in your Social Security card? That could cost you way more than the cost of an attorney. So, as I just mentioned, you can definitely do this entire process yourself, and the entire fee for the process before the medical exam, and assuming you don't need any waivers for grounds of inadmissibility at this moment, April 15th, 2019, it costs $1,760. If you make a mistake in the application, they'll oftentimes just reject it and send the whole thing back to you with the fee. You won't lose your money. But if you make a mistake in the application and it doesn't cause it to be rejected, they'll process it, and then you'll get eventually denied 2 years later, losing your 1760. And now at that point, you're in big trouble because first off, once adjustment of status is denied, the current policy will place you in removal proceedings. An attorney can fix that, but you're going to be looking at $5,000 to $10,000 in additional legal fees. Not to mention, even if you're not placed in removal proceedings, you're going to have to repay that $1,760 plus hire an attorney to fix the mistakes you made. So if an attorney was going to, for example, charge you $2,000 to do your whole process, $2,000 or $3,000, it's going to cost a lot more now to fix the mistakes you made before because it's more attorney hours required. So you can do it yourself if you have dozens of hours and you're not working full time and you have the time to dedicate to it. People still do it themselves. But you should at the very least consult with an attorney before you do it. It will save you a lot of time and money in the long run. It's worth the consultation fee. So yes, you can do it yourself, but at the very least, consult with an attorney before you begin. You may want to even print out the forms, fill them out, have all your questions ready before the consultation so you can get the most out of it. Whenever I meet with somebody and consult with them and they bring in the forms, I don't do document review. I'm not going to go through it because it takes me longer to go through, ask you what's your social and then verify that it's correct, ask you what's your full name, verify it's correct. It's easier for me to just do it myself. So we don't do document review, but people regularly come in with pre-filled forms and they say, look, on this page, this question I didn't know how to answer. And I'm saying, oh, okay, this is how you do it. Or they email me afterwards and with 1 or 2 questions, no problem. We help people out like that. That's not an issue. But at the very least, download all the forms, read all the instructions, and do the best you can if you really can't afford an attorney. But remember, if you do make a mistake and it's a costly mistake, you will end up paying way more in the long run. And if you end up in removal proceedings, it will cost you more than 5 times what it would have initially cost you had you hired an attorney, plus the headache. I mean, in New York, the process right now is taking 19 to 30 months for adjustment of status. You don't want to wait 19 to 30 months only to find out that your application was denied and now you need to redo it. And now the fees have gone up. It's more than $1,760 now. It's just a nightmare to deal with. You're in limbo. You can't leave the country because you're not technically in lawful status and you're appealing your case or reapplying. It just adds a lot of headaches. It makes planning for the future more complicated. Another issue that people, a common pitfall that people incur is when they file the forms, they forget to file certain applications to which they're entitled to. For example, you must file the family petition, the I-130 and the I-485, and that's where $1,760 fee comes in. But if you pay that fee, you can also for free file for a work permit, advance parole, permission to travel, and those 2 benefits are huge. I can't tell you how many times people have come in and told me, I filed the I-130, I waited a year until it was approved. I filed the 485 and I told them, wait, you could have filed both of those at the same time. And they're asking me, where's my work permit? I say, well, let me see your paperwork. You never applied for a work permit. You could have done it for free. It would have taken 5 additional minutes to apply for it. And you could have a social security by now, have joint bank accounts, and much more evidence that you're living a real life with your spouse, which will help you substantially when you go through your adjustment of status interview at the end of the process, like 1 or 2 years later in New York right now. Another major issue that people come across is a common pitfall that people find themselves in is on the 485 application. Like I said, it just went from like 4 or 5 pages to 18 pages. And you'll see from page 10 to like 14 is nothing but yes or no questions. And people freak out when they answer yes to some of those. Watch some of my other videos because I discuss some of those pitfalls and how you should answer yes to some of those in certain situations. But a particular question, if you look up form I-485 on the USCIS website, just Google I-485, it's the first link that'll come up. Look at page 10, question 17. It'll ask you specifically, have you ever violated your non-immigrant status? People, intuitively answer no to this. They say, hey, I came here on a tourist visa, I never violated it, I always left, and then I married my spouse and applied to adjust status in the US. If you entered on a tourist visa and then you applied to adjust your status, you did technically violate the terms of your non-immigrant visa the moment you formed the intention to permanently reside in the US. So for that question specifically, I typically answer yes, I did violate the terms, and in a brief explanation, I just say I formed immigrant intent, the intent to permanently reside in the US while on a non-immigrant visa. So these are things that are kind of hard to figure out without legal guidance. You know, we're doing this all day, every day, and that's why we know this. But, you know, if this was my first time doing this, I would make this mistake as well. So it's just complicated forms, and they make it, in my opinion, intentionally complex. Another issue that an attorney can help you with is speeding up the process. Because if you make a mistake, so the big mistake that people make is on form I-864. A few months after they mail all their paperwork out, their massive package with all the forms, you send it all at once. The I-864 is the affidavit of support, and you're 30% of the time, at least our office 30% of the time, even though we do it correctly, we receive requests for additional evidence asking for more tax documents. These requests for evidence are very vague boilerplate documents, and most people, including us, oftentimes have no idea what they mean. So we just re-prepare the forms, get updated taxes, and submit it. But when you get this request for evidence, it could delay the process by up to 87 plus days. They give you 87 days to respond to it with updated documents. Actually, if you forget to submit any document that's required, you'll get a request for evidence, and it'll delay the whole process, including the work permit, which is supposed to come around 4.5 months into the process right now, currently. By regulation, it's 90 days, but it's taking longer than that at this moment. The other thing is, it takes a long time to prepare the forms. I mean, our office's turnaround time is generally 10 business days, which I know is faster than a lot of other offices, but we can also expedite the whole process start to finish in 3 days. And that includes whether or not you're local or not. In fact, half of our clients are virtual. We do our consultation via Skype or telephone. And then basically I just mail them the paperwork. I mail them some questionnaires. Once they send it back to me, I prepare all the forms. We schedule another video or telephone chat to go through everything, verify its authenticity. And while this is happening, they're mailing me a few signature pages, passport style photographs, and tax documents in the mail. So within 3 days, I'll have all that. By then the questionnaires are done. We review over the phone and I mail it all out. And now your status is pending. So if you've had an opportunity to review all the forms, documentations, guidelines, recent USCIS policies, recent case law, and you decide after all of that it's a little too much, it's not worth your time to take the risk to prepare all the paperwork and ultimately have it denied and referred to immigration court, just, you know, it's fixable, but it's gonna really stress you out and your family and cost you a lot more than it may have initially cost. We're able to handle this whole process for you start to finish, and actually we have clients in most states and actually in many countries around the world who hire us. So again, if you have any questions or you want any assistance with this process, please contact us again, 914-885-3961, or go to darianlaw.com, or contact@darianlaw.com is our email. Thank you again for watching this video.